Good evening. Good evening, everyone. Thank you all so much for coming this evening. We are delighted you're here. Welcome to the magnificent Central Library here in downtown LA. My name is John Szabo. I'm City Librarian of Los Angeles, head of the LA Public Library. We are so delighted and honored to host the California Supreme Court Historical Society event this evening, Inside the Court and Out. This is the iconic flagship of the LA Public Library. This building, along with 72 branches, serve the people of LA every single day. We are a very, very busy place, more dynamic and more relevant than ever. We recently celebrated the 25th anniversary of the reopening of this building. Some of you may remember that. It followed the devastating fire that occurred in 1986, and then there were a few years of construction, and then this library reopened. We are in the Tom Bradley wing now, which is, of course, added on to the Bertram Goodhue designed original Central Library, which this year turned 92 years old. So it is a much-loved building, as you all know, here in the city of LA. And we have about 5,500 people a day that come into this building for coding classes, robotics, checking out thousands and thousands of books, of course, still continue to be a big part of what we do, incredible exhibits. It is a very, very, very wonderful and busy place. Also, if you're interested in the story, a fascinating story of the fire, there is a book that's currently on the New York Times bestseller list, #1 on the LA Times bestseller list, called The Library Book by Susan Orlean. And it is a story of the fire and the wonderful rebirth of the building and the great success of public libraries in the US. So encourage you to check it out or buy it in the library store here at Central Library. I'm very proud to highlight just a couple, 2 or 3 programs that we have here at the library that I think might resonate with you. We have a Lawyers in the Library program that provides free legal help twice a month with attorneys from public counsel at our Benjamin Franklin Branch Library in Boyle Heights, and also at the beautiful Vermont Square Branch Library, which is one of 3 surviving Carnegie Library buildings, over 100 years old in our system. And we also have a great partnership with the LA Law Library, where we provide remote access to databases for legal research, briefs, and information. And our award-winning New Americans Initiative, which provides immigration and citizenship services through partnerships with nonprofit legal counsel providers and also community-based agencies, as well as library staff who have received certification to provide assistance on immigration issues. We started this program back in 2012 with the United States Citizenship and Immigration Service, providing little spaces in all of our libraries with information on the naturalization process, and it has been replicated at libraries all across the country. And then we recently expanded and rebranded it as the New Americans Initiative, and it's, of course, an incredibly successful and incredibly important program here in Los Angeles. I'd also like to thank Linda Riddell Betts, Senior Librarian on our staff, as well as Lisa Schloss, Social Sciences Librarian, for their work in coordinating tonight's event. We have an amazing team at all of our libraries here at LA Public Library. Again, thank you very much for joining us this evening. Please, you may not have the time this evening because the library will be closing, but please do come back. If you have not explored this amazing building, there are incredible collections, public art, great docent tours, an amazing exhibit on the 2nd floor off of the Rotunda that features some of Tom Hanks' typewriters that he has loaned us for the exhibit. He is a total typewriter geek and a collector, as well as a life-size walnut-covered elephant. And I guarantee you've never seen a life-size walnut-covered elephant, and why it's there, you have to go to the exhibit to see. Again, thank you all so much for being here. We appreciate it.
Thank you, John, and thank you all very much for coming. My name is George Abel. I am the president of the California Supreme Court Historical Society. We at the Society are very excited for tonight's program. Justice Werdegar has been a member of our board of directors for many, many years, and we are looking forward to the conversation with her tonight. We, on behalf of the Society, wanted to thank the library, John, very much for providing the venue, and all the support for our program tonight. This, as you can see, is a terrific venue. The reception was beautiful, and we just couldn't have done it without their assistance. John mentioned Linda Riddell Betts, Joyce Cooper. There are literally dozens of people I could name who have really helped out and got our program underway, and I'd like to thank all of them. In addition to Bob Wolf, a member of our board of directors, along with Francine Sheldon. Bob put a lot of time and effort into getting this together, and Francine Sheldon from our office at Paul Hastings helped out tremendously as well. So thank you to both of them as well. The last one other thank you that I'd like to make is for Public Counsel. They are co-sponsoring this program with us and helped to provide the MCLE for those of you who are interested in obtaining MCLE credit. So we thank them for that. And if you are seeking MCLE credit, please do remember to turn in your evaluation forms at the end of the program. There's a box out front for that purpose. So thank you to them as well. I'll finish with one further introduction before we get to our speakers, and that also relates to Public Counsel. Margaret Morrow, you may know, is the president and CEO of Public Counsel, and she is here with us tonight. Public Counsel serves over 19,000 children, families, veterans, consumers, immigrants, and community organizations every year. The policy advocacy and the impact litigation that Public Counsel is involved in affects thousands more of folks who live in poverty, and the work that they do is just tremendous. So we're honored to have Margaret Morrow with us. Prior to joining Public Counsel, she was a judge for 18 years, and she has just done tremendous things for the city of Los Angeles. And so please join me in welcoming Margaret Morrow.
Good evening, everybody. I have the distinct honor of introducing the individuals who will be participating in this evening's conversation. Justice Kathryn Mickle Werdegar and Jim Newton. Justice Werdegar is a California native born in San Francisco. After earning her bachelor's degree with honors from the University of California at Berkeley, Justice Werdegar began her law studies at Boalt Hall, where she was first in her class and the first woman ever elected to be editor-in-chief of the California Law Review. She completed her JD degree at George Washington University, where she graduated, you guessed it, first in her class. After serving with distinction in the Civil Division of the United States Department of Justice in Washington, D.C., under then Attorney General Robert Kennedy, Justice Werdegar was appointed Professor and Associate Dean for Academic and Student Affairs at the University of San Francisco School of Law. Following her stint in academia, she became a research attorney for the State Court of Appeal in 1981, and ultimately for Justice Edward Pennelly on the California Supreme Court. In 1991, she was appointed by Governor Pete Wilson to the First District Court of Appeal in San Francisco. Her appointment to Justice Pennelly's seat on the California Supreme Court followed shortly in 1994. Justice Werdegar served with great distinction on the Supreme Court for 23 years until her retirement in 2017. During her time on the bench, Justice Werdegar was known as a rigorous and thoughtful legal scholar, as a consensus builder, and as someone who always placed the rights of people above politics and ideology. Throughout her tenure on the Supreme Court, and even today, Justice Werdegar has been an enthusiastic supporter of and contributor to the California Supreme Court Historical Society. Joining Justice Werdegar on stage tonight is acclaimed journalist and author Jim Newton. Jim is a Dartmouth College graduate who began his career as a clerk for New York Times columnist James Reston. After working as a reporter at the Atlanta Journal-Constitution, he spent 25 years with the Los Angeles Times as a reporter, bureau chief, columnist, and editor. He was part of the teams of Times reporters who won Pulitzer Prizes for their coverage of the disturbances in Los Angeles in 1992 and the Northridge earthquake in 1994. He's the author of 3 best-selling, critically acclaimed books: Justice for All, Earl Warren and the Nation He Made, Eisenhower, The White House Years, and Worthy Fights, a memoir of leadership in war and peace with Leon Panetta. In 2015, Jim joined the UCLA Luskin School of Public Affairs, where he teaches communications studies and public policy, and is the editor of Blueprint, a magazine that addresses the policy challenges facing Los Angeles and California. He's at work on a fourth book, whose working title is Jerry Brown and the Creation of Modern California. So Jim and Justice Werdegar, if you'll please come out.
Thank you very much.
I'm going to turn this over to you, Jim.
Thank you. Thank you very much, Judge Morrow. Judge Morrow, more important than all her other accomplishments, is also my friend and neighbor. So it's nice to have you here. Thank you. Thank you all for being here tonight, for joining us for this evening. It's really a pleasure and honor to share this stage with you, Justice Werdegar. We're going to talk a little bit about the court tonight, as you might expect, also California life and politics. First, though, I think we have to get the elephant out of the room, which is to say the events of today and yesterday. I know you come from the least political of our branches of government, but I wouldn't be an interviewer if I didn't ask for your thoughts on yesterday's midterms. Any reflections on what happened with the country?
Well, you said the elephant out of the room, the elephant and the donkey out of the room, right?
Very good.
It seems that each side is able, in some regard, to claim victory. That's what I'm hearing, and it makes sense to me. And how the new balance will play out remains to be seen, but holding on to the Senate strongly is no small accomplishment. Taking over the Congress is a great achievement for the Democrats. And we'll just see, yeah. But another observation I'd make is that it's been said, and we know it's true, that this morning started the campaign for 2020. So if we think we're finished with the election because we cast our ballots and we got the results, no.
Yeah, we all need to take a deep breath, probably.
Yeah.
Okay, so enough of that. Let's back up. Tell us, we heard a little bit from Judge Moore about your background. I wonder if you could talk a little bit about coming up as a lawyer, law student and lawyer here in California, particularly at a time when there were not many women in your profession.
There decidedly were not women. When I went to law school, it was my understanding that in the United States, 1% of attorneys were women. And California progressive, as always, had 3%. It didn't dawn on me that this was going to be an issue or a problem. This was just an education that I felt would take me. I didn't know where, and I was happy to have the education. What was it like? When I came back from Washington, of course, the federal government really does not discriminate, and it didn't at that time. I was hired in the Justice Department in the Civil Rights Division after graduation. But I came back to California, and the non-discrimination law hadn't been passed yet, and firms could actually say, they didn't to me, to my face, but they could say they weren't going to take a woman. The clients wouldn't like it, or the senior partner wouldn't like it. Berkeley Law sent me over to one firm. They looked out for me a little bit, even though I had gone on to George Washington, and said there was one firm in San Francisco, a prominent firm, that was thinking of taking its first woman if the others could persuade the senior partner. And I had a lunch with them, but I just don't think I was the best to interview. In any case, the senior partner wasn't persuaded. But I was mostly oblivious, Jim. I did not cross my mind about discrimination, to be honest. I was very naive. And maybe it wasn't discrimination. You don't know. You can't go into every situation thinking that's discrimination.
Right.
They might have had another candidate.
And what about in school? Governor Wilson, later Governor Wilson, your law school classmate,
Yes.
famous for having said that he and his classmates started by wanting to carry your books and ended by wanting to copy your notes, which it may say more about Governor Wilson than it does about you, but your
I appreciate that.
does that indicate an attitude that you experienced at Bolt?
Again, I think I was oblivious, truly. I didn't sense any unwelcomeness except from famous Dean Prosser, who was on record as not wanting women. A woman in that era, folks, you have to really go back, was thought to be taking a man's seat. a man who would need that seat and the woman would not need it. It was frivolous. No, I think I was nicely accepted by professors and students. It's only looking back that I realize how unusual it might have been.
You mentioned in your oral history, which I read with interest, the different rooms. There was a room, very small.
The lounges.
Lounges, I
Yes,
right.
there was the men's lounge and the women's lounge. And, 98% of the individuals were hanging out in the men's lounge. We did have some women getting their masters in law beyond what at that time was LLB. Yes, so when I'd go to my reunions, which I've only gone to a couple times, but the guys would talk about this and that they did in the lounge and playing bridge and doing this and, I had no idea. And going back to the paper chase, which came out afterwards, but if study groups, if they were having study groups, I didn't know about it. There was so much that perhaps was taking place that I was unaware of.
Do you feel like you missed something?
No. No, no.
Let me ask you a question again that comes up in your oral history that I thought was provocatively referenced in here, which is to ask about the value of diversity on the bench. And to ask it this way, would a smart, experienced woman decide a case any differently than a smart, experienced man?
Perhaps you're aware of Sandra Day O'Connor's comment. When I was appointed to the Court of Appeal in San Francisco, it was a 19-judge court. And at that time, I was the only woman among those other 18 males. And it came to my attention that Sandra Day O'Connor had said, her appointment was so historic. She had said, a wise old man and a wise old woman will come to the same conclusion. And I thought, really? Is this true? A lot of women academics at that time were trying to discern if there was a woman's voice. There were so few women on the bench, maybe a few more on the federal bench than on the state benches. So they were analyzing this minute material that they had to work with. So I myself thought about that. Fast forward, I have now on the Supreme Court sat with 5 different women judges over time. And I would say to you that we are as alike or as different as any 2 random judges of any sex.
The court that you left was majority women, was it not?
The court that I left, when I left, had a majority, and now it's balanced, and we just don't know what's coming. Yes, that was that was quite something. And when I joined the Supreme Court, I was the 2nd woman. But as you say, we've had for many years a majority, including our Chief Justice.
How do you think it's appropriate to value prior judicial experience in evaluating the credentials or the qualifications of a nominee to a Supreme Court, either California or
When you speak of judicial experience, are you thinking about the trial court or any court, the Court of Appeal?
Well, I leave it to you to answer any way you want, but I guess I was thinking about either or both. But
well, of course, the appellate courts are so different than the trial court. Each governor has had very different approach to this. Governor Duke Machen, you started in the Muni Court. Preferably, you'd been a DA before, and then you started in the Muni Court, and if you acquitted yourself all right there, you'd be elevated to the Superior Court, and maybe if lightning struck, you'd get up to the Court of Appeal, and there it went. That was his vision. When Wilson came along, and I was his first judicial appointment, he was breaking the mold there. I had sat by his appointment on the Court of Appeal, but I hadn't done all those boots on the ground, other things. We all know that our current and former governor, Jerry Brown, has a very different attitude. 3 of my new colleagues, by his appointment, he has a 4th coming up. 3 are all never been on any court and are academics, really. What do I think? I think you need it all, frankly. Most of our issues, going back to the trial court, except in criminal law when you're dealing with a Wheeler-Batson motion, a jury selection was their discrimination. When having been in the court itself. You might have a feel for how those things go. Otherwise, our issues don't deal so much with trial court procedure. Those cases stop at the Court of Appeal. As all of you in this room, I think, know, we have discretionary review. And out of all the petitions for review that come to us, we might take 3 to 5%. So our issues are more philosophical, constitutional policy. So professors have a lot to say about that. You want a complete mix, and with 7 positions, you just can't have every ethnic and background mix that you would want.
Right.
You want experience, like Marvin Baxter was a farmer, and that was good. He brought that. I sat with Stanley Mosk, which was great fun. He had a lot of political experience and common sense. And so I don't think there's any clear answer, but you don't want all the same. You don't want all DAs, and you don't want all professors.
Are other members of the judiciary resentful that Jerry Brown has not put on experienced judges on the court?
I wouldn't know.
Well, they might tell you.
I mean, I think those in the Duke Machen days, you had a stepping stone that if you distinguished yourself as a judge, then if there were an opening on the Supreme Court and you had some connections, the governor has to know something about it. You might have a hope that with all your hard work and your service, you would have a shot. So in that sense, not speaking to what I know about people's attitudes, but I think it's natural. They'd think, well, wait, we've been serving here
hard
for 25 years, and you pluck somebody out of some old law school.
I would think. California has an unusual system for appointing and, of course, retaining judges and justices. We've just been through a round yesterday. What is your assessment of the way California handles the retention election or deals with that as part of the judicial process?
I have said often, I think California has the best system. The judges at the appellate level are nonpartisan. They cannot run with any party affiliation or backing. They're nominated by the governor. They're reviewed by something called the Judicial Nomination Evaluation Committee, which is an arm of the state bar. And if they pass all that and the governor chooses to appoint them, there's a commission comprised of the Chief Justice of the state and of the Attorney General at the moment and the most senior presiding judge of the Court of Appeal. And as you referenced, we are retained. It's not political, it's not contested. If we're not retained, as happened many years ago historically, 3 justices in the Rosebird era were not retained, nobody takes their place. It's not a contested election. I've thought our system was excellent, actually.
Is there, compare it or contrast it to lifetime tenure benefits?
Well,
versus...
I don't think lifetime is good. I think somebody has pointed out that when the United States Constitution established lifetime appointments for the United States Supreme Court, life expectancy was very different. And they didn't anticipate that anybody would be sitting for 30, 40 years. That's not going to change because it takes a federal constitutional amendment, and most of us here understand that that's the most arduous process, and on this issue, it would become very problematic and contentious. So I think fixed terms, the nightmare is contested elections. And you're probably aware that some states have that, and it's very political. It's terrible. We're supposed to be a sort of an independent, neutral branch. I know that in various quarters across the country, and it's moving away from that in the perception of the public. California, even though each governor appoints people that they hope will advance their policy. There was once a cartoon, did you see it, Gray Davis? I don't know what he did to deserve this, but it was a political cartoon, and there were 7 faces at the bench. They were all Gray Davis's face. And he said, I want my judges to reflect me or something. So the appointing authority hopes that you'll be in tune with their philosophy and their view of the world, but they don't have a lock on you, and we're free to do as our instincts and best judgment.
And you referenced the Rosebird retention election with the
Yeah.
other two justices as well. Do you worry at all that that was an example of, are justices influenced by that case and the fear
Well, when
that
it
they might not
happened,
be retained?
I don't think it had ever happened in California history before, and I was a staff attorney at that time on the court. And irrespective of your politics or your views of the court, those of us who were professional and worked there, I felt black bunting should be wrapped around the building. It was shocking. Maybe we were naive. I think more of that's, I think certain special interests will occasionally try to remove judges. As you might know, that campaign, I'm told, was based on the so-called Bird's Court so-called failure to affirm any death penalty judgments. It was a new death penalty, and you could say they had to work through the nuances. Whatever, they didn't. They reversed and reversed. So it was pitched to the public that they won't enforce the death penalty, which Californians at that time and maybe to this day still favor. But the money behind it came from business interests that didn't like the tort judgments that that court was advancing. So it was a very dark period in our history. Some years back when Ron George was chief, he and Ming Chin, who were on the ballot that year, did mount a retention campaign because there were certain interests that were threatening to throw them out based on their vote in the parental consent case, where the Supreme Court at that time said that the state law that required a minor to get parental consent or a judicial permission to have an abortion, that law was an invasion of the minor's right to privacy. A very, very divisive issue, and it got a lot of people up in arms. So Ron George and Ming Chin got campaign consultants and raised money.
And won.
They won, yes, yes. So it's not a perfect system. The role of the judiciary in our society is very complicated.
Point taken. Okay, another quirk of California politics, the initiative. I know you've talked and thought a lot about the initiative process. How is the initiative process wearing on California these days?
Well, you all voted. How did you like all those initiatives? Shall we abolish daylight savings time? Shall we extend rent control? Shall the dialysis centers, be restricted? I mean, I voted on these, and afterwards I read what they were supposedly about. And so the initiative, as we all know, I think, it was a reform measure more than 100 years ago to relinquish or go around the stranglehold on the state legislature that the railroad interests had. It was a populist move to give the people a voice. So it's direct democracy. You don't go through the legislature to pass legislation, you do it yourself. As time has advanced, our state has grown. We're so much larger. And there are those who would say that the initiative process has been hijacked by this very special interest that it was intended to get around. Initiatives now are put on the ballot to advance certain special interests. And of course, it takes a lot of money to get an initiative on the ballot now. You have to get signatures of, what, 2/3 of the people who voted in the previous general election,
Right,
something
or a
like that.
percentage, yep.
And we're a huge state. And so you have to pay people to get those signatures. And good citizen groups don't have, whatever they may be, don't have that money. However, so it's complicated, and then people don't understand them. I often feel we're asked to vote on things that we shouldn't have to be thinking about. That's what we have our legislators to think about. One real difficulty with the initiative is if in practice it turns out not to be working well, how can you amend it? Legislation, the legislators can get together and amend the law. Initiatives, you have to pass another initiative and go through the whole process. The 3 Strikes initiative, which was extremely popular in its time, over the years, people, entities, the public began to feel it was too severe because the 3rd strike, you'd read these stories of somebody stole some golf clubs and it's his 3rd felony. He's behind bars for 25 years. In any case, they tried 3 times to ameliorate it, to modify the 3 Strikes law, and it took 3 times. On the 3rd time, the law was modified to say that 3rd strike can't be just a felony, it has to be a violent and serious felony, and there are differences. Same with term limits. That was put in by initiatives. And people loved that at first. And then over time, people began to feel this is too restrictive. There's too much revolving door. We want to modify that. They had to do it by initiative. And I think that took a couple of initiative cycles. On the other hand, California has reapportionment by citizen committee. That was an initiative measure. In other states, the legislature, that's the legislature in power, does the initiative. You weren't going to get that, that reform through the legislature. So the initiative worked very well in that regard.
There's something I think that many people, certainly I, find uncomfortable about the initiative, particularly when it comes to criminal justice, that there seems something sort of crude about it. I mean, would we have, if baseball had 4 strikes, would we have 4 strikes in California? I mean, there's something that seems populist and kind of blunt instrumenty about it when it comes to something as delicate as sentencing.
Well, there's no question about that. You're absolutely right. And again, these are broadly written, often by special interest, and often with the intention, I'm told, of getting certain segments to the ballot box, if you can get their blood up and get them interested in this initiative. So it's a manipulative tool. Yes, for the general public to be dealing with matters of criminal punishment that require sophisticated insights and experience, it's questionable.
Are there ways that you think that we could amend the initiative process that would preserve some of the benefits you're discussing while ameliorating some of the difficulties?
I'm not an expert on this, but there is an entity, one at least, called the Think Long Committee. Perhaps you've heard of it.
I have, yeah.
And I understand, and maybe the legislature passed this, they did recommend some reforms, which I think are very good. One reform was that any proponent of an initiative had to present it to the legislature before it goes on the ballot, to see if the legislature would then, oh, you're interested? We'll look at this issue, because they have hearings and they have experts. And also to put that proposed initiative online so citizens could comment. I think that has been implemented, but how it's worked out with any given initiative, I don't know. The other reform, which I think is very helpful, is they had to disclose the top, 6 contributors. Because who's behind an initiative often tells you what it's really about. They're very confusing, and the titles. Now take Initiative Prop 6. You all know what Prop 6 is?
The gas tax, right.
This was the gas tax. Well, the proponents wanted it to be called Repeal Taxes. The opponents, this was going to repeal certain taxes that are imposed at the pump to build our roads and so forth. The proponents, and I think they prevailed, and it's the Attorney General who decides, wanted to call it eliminates money for road repairs. So you have, repeals taxes or leaves your roads rutted. And what's the public to do?
Right.
It didn't pass, by the way.
Right. I want to shift for a little bit and talk a little bit about life on the court. I wonder, as a starting place, I wonder if you could talk a little bit about, you served with 3 different Chief Justices,
I did.
right? Will you take a moment and talk about the role of the Chief Justice and how those different Chief Justices manage the business of the court and the life of the court differently? Or
Thank you. The role of the Chief Justice is really administrative. And Ron George used to point to his robe hanging on his hanger back there and say, that's the part of the job I love. But their role is administrative, going up to Sacramento and persuading the legislators to give us, we are at the mercy of the legislators in our budget. And Ron used to say, there are fewer and fewer lawyers in the legislature than there used to be traditionally, that some of them wouldn't know the difference between the judiciary and the DMV. And that was kind of a struggle for him. So the role. With respect to the interior workings of the court, the interesting thing is, well, the Chief Justice does assign cases once we grant a case. And that assignment, you might think, is somewhat of a power. But the real hope is they will assign the case to somebody who can get a majority, and it's not who can write a decent opinion. The Chief Justice has apart from that, no greater influence on any given judge, no matter what. If somebody's obstreperous, if somebody's not producing their opinions, it's interesting, the chief has, each judge is a constitutional independent offer. The personalities. I came late in Chief Justice Lucas's career. I won't be the first to say he was right out of central casting. I mean, tall, shock of white hair, rimrod, and poker face, but a very wry sense of humor, a true gentleman, and just a delightful fellow was my experience with him. When Ron George came in, he came in with just raring to go, high energy, a vision for the courts. He wanted to assure that the courts maintained or re-achieved their position as a co-equal branch of government. And he was behind the consolidation. It was an initiative, I think, but the consolidation of the municipal court, remember municipal court? And the superior courts, and statewide funding for the courts. So he had an administrator's vision for the good of the courts. As a person, he was absolutely delightful. He too had a great sense of humor and high energy. And he had a talent that also our current chief has. We can be kind of annoying, we members of the court. You know, the cases are contentious and certain issues come up, and we're not all buddies necessarily. We didn't know each other before often. And he had a way, and our current chief does as well, of just this very neutral, cordial way of treating all of us. And something will happen in conference that you know has to be extremely irritating. With neither of these chiefs would you ever know it. So Ron George was great at doing what he did. When he left, the administrative office of the courts, which is our administrative body, had about 800 people. And that had grown considerably under his tutelage. I will say that I happen to have known the very first ever administrator of court, Ralph Kleps. Do you know the name?
I know the name, sure.
And Ralph Kleps was, in fact, our administrative of the Office of Courts, I think, was the first in the country. And I think Ralph Kleps did start it, and when I knew him, he had a staff of about 6 attorneys. Well, fast forward, I'm still in the law, and Ron George is chief, and there are 800 employees. So there was a little feeling about that. It had grown too much, but he left that to our current chief. When Justice Tani Kantil Sakaui came on, the state budget was in bad shape and the courts began to suffer fiscally. And that was a real problem that, you know, she couldn't have anticipated that she was going to have to face, a very difficult problem. And also there was a splinter group of judges came out called the Alliance for Judges that were in opposition to whatever Ron had been doing or the administration of the courts were doing. This was new to me that judges would have internal fighting. So she had to face that. As you all probably know, if you've ever heard her speak, she's gracious, she's articulate, she's poised, and I just think she's marvelous, admirably marvelous. And again, you know certain things happen in conference or certain people say things. But to look at these chiefs, you'd never know that they were flapped. I would say California's been very fortunate. Each of those chiefs have been outstanding and very good for the time they served.
Yes, Justice Kantil Sakaui was I thought, very persuasive and effective on the budget issues. Well, I remember when she came through when I was at the time still, was a very effective lobbyist, particularly, or lobbyist in the grandest sense of that.
She had no honeymoon period at all. She was appointed, it was very exciting, her appointment, but she really had to hit the ground running on fiscal issues.
Ask you about a couple of cases. You took I think it's safe to say, a novel position in Merrill versus Navigar. We talked about this a little bit, which, for those of you who don't know, is a gun case growing out of a 1993 shooting at a law firm in San Francisco that left 8 people dead and another 6 wounded. You dissented in that case, and you argued that Navigar, which is a gun manufacturer, had acted negligently, pardon me if I summarize this incorrectly, but had acted negligently by marketing a military weapon to civilian purchasers, right? That, in other words, that not that the guns were faulty, but that they were distributed negligently. I suspect a lot of people would find that argument quite compelling today. I had 2 questions from that. First, would your reasoning in that dissent stand the test later created by the Heller case federally that concluded that individuals had a right to bear a weapon, an individual right to bear arms? And second, more generally, I guess I was curious whether you believe that the U.S. Supreme Court has left sufficient room for state and local governments to improvise in this area and to regulate weapons.
That's a lot in that question.
Sorry, yeah.
Let me start with the last part. Do I believe the Supreme Court has left enough room? That remains to be seen. There has to be a will in the individual states to do it, and whether there's room, I don't know. I think my argument, which I'll address just a little bit, in the Merrill versus Navigar case, yes, still stands. What happened there is California had a statute that said gun manufacturers cannot be held liable for harm done by their product because of the way they designed it. Now that's a statute. And there's an interesting history to this court, which I will, this case, which was, we granted review, we heard argument, and it was assigned to me. The statute said what it said. And I wrote a draft opinion saying there's no liability. That's the statute. We have no power to go beyond the statute. That circulated. Everybody agreed. We had oral argument. We came off the bench, and my staff attorney came to me and said, I heard something in argument, Judge, that I want to discuss with you. What came out of it was, at the trial court level, the plaintiffs who were the survivors or the loved ones left behind by this massacre had at the trial court level advanced the theory, it had never been tried, it had been thrown out of court, that the manufacturer was negligent for the marketing tactics. These weapons were advertised in these gun enthusiast magazines, Soldier of Fortune, what have you, as rapid fire, fingerprint proof, easily assembled, easy assembly of a silencer, and low cost. There's no place for weapons like that in the civilian, there isn't. They may be in the military, maybe in law enforcement, but we don't need fingerprint resistant, rapid fire, rapidly reloading silencer weapons. So this theory came to my attention, and I had the responsibility, clock runs after oral argument, to, the case had been assigned to me, everybody agreed, they expected the opinion that I was gonna do. So I wrote two opinions. One was my new theory. Look, we didn't really get into this. Look, these people should have the opportunity to go to trial on the issue. I didn't say the manufacturer could be liable, but they ought to be able to have a trial. So I circulated these two opinions, and nobody agreed with me. So the case was reassigned, and my second opinion became my dissent. So that's how that case evolved. I think that theory, I don't know what marketing is going on now, but law enforcement, there was evidence, testimony, or would be, there were written articles, that that weapon was the most widely used by the criminal element. The manufacturers who are marketing this to the public are charged with knowledge of that. We have more guns in this country than we do people. I just read that. So I don't know where gun regulation is going to go. And what the United States, what elasticity there is, I'm hopeful there might be some.
Completely different area of the law, same-sex marriage. You joined the majority that upheld same-sex marriage in California. Have you been surprised by the speed with which that issue has evolved?
I definitely. Who hasn't? When I heard about domestic partnership, I thought, oh, that's good. That's a really good idea. That works. And that gay marriage, what? Marriage? Ooh. But it happened, it evolved so quickly, and it came to our court. I don't think we were the first, but we did, Ron George's opinion in the marriage cases came out saying he did the same thing in different circumstances. One opinion saying you can't have gay marriage, one opinion saying you can, circulating it. Yeah, it's in his oral history. And he wanted to give everybody the chance to, but he turned out to be the swing vote because it was 4-3. I was very surprised how rapidly thinking and awareness evolved. And then, of course, talk about the initiative. In California, a bare majority of voters can overturn every constitutional decision of the United States, of the California Supreme Court, not the United States Supreme Court. So that went on the ballot, and the voters said, no, a marriage is between a man and a woman.
Same ballot that Barack Obama was elected on, in fact.
That brought what?
Barack Obama was elected on in 2008.
Oh, so that was gone. But then it went through the federal courts, and ultimately the United States Supreme Court held that there is an equal protection right to same-sex marriage. I was very surprised.
Do you approach, or did you approach writing dissents differently than majority opinions? You just described two with a sort of unusual histories.
Very unusual,
Is it in more normal cases? I've heard it said that sometimes a dissent is a more liberating act of writing. You don't have to worry about majorities. I'm curious.
Well, you're right about that, because when you're writing a majority, what you hope is going to be a majority opinion, you want to bring in as many people as you can. And when you're doing that, you might leave out something that you personally want in there, but it's not critical, so that you'll get somebody's vote. Or you might put in different language just so somebody is more comfortable. Yes, you're free with a dissent, but I don't use dissents to excoriate my colleagues or chastise them. But I'm very fond of my dissents.
That's right.
I am, because you don't write a dissent unless you feel strongly about a subject. You don't have the time or the inclination. And so if you're writing a dissent, you're really invested in that point of view.
If you were to read back over your opinions over the years, would your dissents be the way to gain insight into your
I think so.
judging? Is that right?
Yeah. Well, it would be one way. My majority opinions would be another way.
Very good. Well, okay. Note to historians. What are some of the areas of the law that you see developing in California today? I know you've written a lot on environmental law and Sequa. Maybe that's one, or others. What's in play right now?
Sequa will be with us forever. Sequa is such a complicated law, and it's never going to stop, because it's development versus the environment, which California is interested in both, and we have a law addressing how that's balanced. Privacy, water, let's see. Well, certainly privacy is an area. Of course, ultimately, well, California has a state constitutional provision guaranteeing privacy, so we can develop our law a little differently than, but with all the electronics and so on, you wonder, do we have any expectation of privacy at all now? Water law will always be here.
Can I stop you there? I hate to interrupt, but back to privacy. What are your thoughts on that? When you say the question of whether we enjoy any privacy at all anymore, is that
I've only pondered the question. The issue when we were in law school was so simple, but now I think the test in an unreasonable, unlawful search is whether you had a reasonable expectation of privacy. And the question just philosophically is, who does? But of course, we still pretend that we do. It's a brave new world.
And you mentioned water. I'm sorry to interrupt.
Well, of course, water is such a critical issue. There might even have been something in the initiative this time about water.
There's a water bond, or one or two, I think.
Yeah, water is a real problem. And the courts will be called upon to strike conflicting claims and so on.
Is that one where you see California really setting a standard for the country?
Well, we have particular water problems. Indeed, we do. So I don't know about setting a standard for the country.
Back to Sequa again for a moment. Sorry to skip around, but overall, has Sequa been beneficial to California?
I'm not one to say. There are those who say it's a really obstructionist piece of legislation that people abuse by stalling projects they don't want. And I expect there's truth in that. But on the other hand, it is designed to have thoughtful, considered development with the least negative impact on our environment as possible. Sequa has a broad reach, and I want to explain this. One of my early cases was called Save Tara versus the city of West Hollywood. Tara was a historical building in West Hollywood, and the city, I think, had voted to demolish it, and the preservationists felt that was the wrong thing to do. So they sued the city for an inadequate environmental impact report. Every project has to have an environmental impact report. So it came to us, and our court said that the city had not properly, procedurally handled the environmental impact. That's all we said. It turns out, though, I recently read that Tara was saved. I love the name Tara. And it's in a public park in West Hollywood. One of the last cases I had involved what's been described as the largest land use project in the history of California, where there was proposed a city of 20,000 people. I don't know where all this land is. Can you imagine the environmental impact issues in a project of that size? And of course, litigation on it has been ongoing for years. So it finally came to us, very, very complicated, and not a unanimous opinion, but majority, I think more than necessary majority, held that there were still inadequacies. You have to consider the impact on water, the impact on traffic, the impact on wildlife, and now we have greenhouse emissions, gas emissions that have been, I don't know how scientists project all this, but these environmental impact reports have to consider those things. It's beneficial because it goes back and they rethink it and they can suggest mitigation. It's not that a project is stopped. They're supposed to be as thoughtful as they can about mitigating environmental dangers. I had one case where the concern was the stickleback fish. Now, I'd never heard of a stickleback fish, and maybe some of you know what it is, but a staff attorney got me a picture of this little fish with a little stickle. They were moving it from its normal environment to another to do a project. So Sequa is complicated. The legislature can modify it. It has done some modifications.
Mm-hmm. There are those who make the argument that it discourages businesses from relocating here because it's so complicated.
I think that's probably true. That's one of the balances, and that's up to the legislature. The benefits, we need development in California. Nobody can, we can't stop it. So the legislature, those kinds of issues are for the legislature.
Mm-hmm. The one other broad area that obviously confronts the court, confronts all of us really, is technology and science. Is the, and in the court, I assume everything from policing the internet to climate change, these must come up regularly. Is the court well equipped to handle highly technical, scientific, technological questions?
Probably not. I mean, we certainly don't have any expertise that way. We get briefing and amicus briefs and so forth. You can't call up your science professor. I've often thought on the court it'd be so nice if I could call up somebody who really knows something besides the parties, but you can't. A lot of these issues belong more appropriately in the legislature. They're probably not equipped either, but they can get witnesses.
They can bring people in,
and they can
right?
do research. So we do science gets ahead of us. Technologically, as an institution, I think we've been a little slow, but I'm not the person to criticize because I'm a little slow. But on the issues, for instance, here's an issue. How many parents, how many mothers do you think a baby can have today? A mother can have at least 3 mothers. The egg donor, the surrogate mother who carries the baby to birth, and the woman who with her husband contracted to have that baby born. If the agreement falls apart, who's the mother? That's the kind of question a court's asked to decide. And stem cells, there was a case many years ago when you go in for surgery and tissue is removed and you're healed and you go home. But the hospital retains, unbeknownst to you, your tissue and extracts certain cells from it and processes it, and all of a sudden they have an industry based on your biological material. Well, who owns that? Do you have a right to own that? Other technologies, I mean, these cell towers that tell everybody where you've been, is that an invasion of your privacy? Does that require a search warrant to use it? So there are all sorts of, there was a search and seizure case that I happened to author, the dissent. You know, when you're arrested, search incident to arrest, they can take your wallet, your pocketbook, your address book. In this instance, they took the individual's cell phone and held on to it for several hours, and they decided they'd go plowing through it. So the case came to us, was that a search incident to arrest? Always legal? Well, the court held it was, but I dissented, and I said in this new technological era, this is not like your wallet. You're going into photographs, bank accounts, contacts. Of course, that's what they wanted, but, and I lost. But the United States Supreme Court took the issue up later, and they went the way that dissent went. They said that your computer or your cell phone, these smartphones, are different than your wallet.
Right, it's an encyclopedia of your life, really.
It is, yeah. So the courts do the best. My colleagues who said it was fine, they were analogizing to, as I say, wallets and address books and the drugs or the cigarette box that was in your pocket.
But the reasoning by analogy is difficult in these technical cases.
It really is. I had a case where some disgruntled employee left the firm he was working at and inundated it with emails. So they were very annoyed, and they sued for trespass to chattels. Chattels are things, yes. An inundation of emails is not the same as, you know, damaging somebody's property, which is trespass to chattels. And we had to decide that, yeah.
For you. A few more. I know we want to leave time for you to sign some books outside, but let me ask you just a couple more. A lot of talk in Sacramento today, and probably more starting tomorrow, about California serving as some kind of base of resistance to Washington. Particularly, obviously, in areas like climate change and immigration, where California seems to have a different set of policy perspectives than the Trump administration, anyway. Is there room legally for California to chart a really independent course from Washington in these areas?
Well, insofar as your question relates to political issues, I have no idea. But insofar as civil liberties, we do to an extent, because we have our own state constitution, and the California state constitution has its own Bill of Rights. And we tend, it seems nowadays, to be more protective of individual liberties than some other states or maybe the national government. And in the past, we have been the first. We were the first to strike down the laws against miscegenation, intermarriage, racial intermarriage, long before the United States Supreme Court did that. And our Supreme Court was the first to apply the exclusionary rule to illegally seized evidence, that you couldn't put it in court. We were one of the early ones to recognize gay marriage. We weren't the first. Of course, the voters threw that out. But there's some room in that regard for California to be a leader. I can't speak about how it's going to go or what the policies are going to be about immigration. I'd like to say something about immigration. I think all of us, and certainly students, could benefit if we knew what the laws of immigration actually are. I mean, how many can tell us how a person can legally immigrate, how the process goes, who gets to do it? How I can't, and I really intend to study it. So we know what all the hue and a little bit about what the hue and cry is about.
I suspect that the president probably can't answer some of those questions, but anyway, I won't make you answer that. Sorry.
Best you ask him, not I.
Two final questions, one obligatory and one I hope is more hopeful. First, and I apologize for feeling I need to ask you this, but I do. What do you think about the confirmation hearings for Judge Kavanaugh?
I thought they were terrible, painful to watch. Painful to watch. I mean, you might say, well, in what way was it painful?
Unfortunately, that's exactly what I was going to say.
I don't know where to start. It's a question as to, starting out at the beginning, whom do you believe? And people across the country had different takes on that. But moving then into his response, I think his response was very disturbing in the sense that it was so immoderate and intemperate. And when a nominee to the highest court in the land retorts to a senator without asking the senator's question, answering it, asking the senator about her drinking habits and her preferences, it's discouraging. I don't know how historically, I don't think the United States Supreme Court in the beginning was supposed to be so politicized, and I think politicized is a fair word. However, this is not new. When I was a little girl, there was the Earl Warren Court, and there were signs that said, impeach Earl Warren. And there are people to this day who resent and think it's wrong and, illegal what the Warren Court did with various criminal rights and civil liberties. So it's really not new. The court has really been political. When somebody takes the bench, do they change? Do they take on a greater sense of responsibility as to the power they have? With any given judge, we look to see that.
Did you feel that in your own life, in your own experience once you were on the bench? Did you feel differently about it?
Well, I certainly felt a responsibility, but I didn't come with anything that I had to put aside that would impede my being an objective judge. Judge Kavanaugh will have to. I mean, he made it very plain where he stands on many issues. And the question is, will he recuse himself? You're not supposed to say how you feel. And he has on many things. We'll see how he comports himself on the bench.
It's hard to imagine him, for me anyway, handling a case for a liberal civil rights organization, for instance, now that he's said so clearly that he believes he's been the victim of those organizations.
We'll see. It's up to any given judge on the United States Supreme Court whether they choose to recuse.
Finally, more hopefully, I believe my goddaughter is somewhere in the audience here, and I imagine her sitting in your seat someday. She's a young lawyer here in Los Angeles. What advice or thoughts do you have to young lawyers, particularly young women, who are entering the profession now and want an illustrious career such as you've lived?
Well, that's a broad question, but I would say for someone who aspires to be a judge, well, where do I start? Can I talk about women?
You can talk about anything you want.
Yeah. Well, I think it's always best that you find a field of the law that you're passionate about, and you excel and you do the best you can. Now, we're talking about aspiring to the bench.
I'm really just talking about
well,
the
just
desire
please
to...
find a field that you love, and if you don't love what you're doing, find another one. And truly, because law can be marvelous. Some people hate it, and some of us just love it. So if you're not liking it, please find something you do like. For women, it is a challenge because even though younger men are much more egalitarian in the home and so forth, women still tend to carry the burden of the child care or the ailing parent and so on. Ruth Ginsburg accepted, I mean, she said, this child has two parents, you know. She's quoted as saying that when the school would call her. And her husband, Marty, was just marvelous, did all the cooking and so on. But usually it's not the case. I would say just carry on as best you can, keep your hand in the law, do what you love, and hope for the best. If you want to be appointed to the court, you have to be brought to the attention of somebody, the local bar groups or your activity in your community. You have to do something beyond just try your cases, I think. But I would say to any aspiring young lawyer, I hope you love it. I love it. And it's just a wonderful career. You can have such an impact on people's lives. Really, when people need a lawyer, they really want a lawyer. And various causes need lawyers to advance them too. The head of public counsel introduced us, and organizations like that can have such a wonderful impact. It's a wonderful profession.
Before we go, before I release you, a few thanks to public counsel for co-hosting tonight's event and for making Los Angeles a safer and more welcoming place. To the California Supreme Court Historical Society and yourself for co-hosting and for preserving the history of this institution and state. To all of you for making it out here after a historic and somewhat exhausting election. And finally, and most importantly, to you, Justice, for being with us this evening, but far more importantly, for dedicating your life to the service of the state and country. We're all in your debt.
Oh, well, thank you very much.
I want to remind all of you that there are copies of the Society's History of the Court that are going to be available outside this room. Justice Werdegar has agreed to sign. You'll also find copies of Blueprint Magazine that I edited at UCLA. They're free. I hope you'll take a copy and enjoy it. With that, I thank you all for coming and appreciate you being here.
Thank you.
Thank you.
Thank you so
My
much.
pleasure. My pleasure.
Drop the wall.
Right?
Do we now exit gracefully
I think we
behind
actually
the curtain?